Good morning, everyone. Welcome to our Black Friday webinar. We're very happy that you could join us today. I want everyone to just breathe, take a deep breath. We're going to go through some issues that are happening as we go, some things for 2021 that are going to be in the future, and things that you can do to plan today to prepare for that future. So sit back, relax, soak it in. We will be taking questions during the presentation. There's a way on Zoom, if you go to the Q&A, that you can post your questions, and we'll get to as many of them today as we can. If we don't get to yours, we will respond to it individually by email. And I'm very happy that my partner, Peter Strauss, is able to join us this morning. Peter is down in our New York City office. He is a lifelong Manhattanite. And together, Peter and I have just about 100 years of legal experience. I won't say who has more, but we have been living with this area of law for a very long time, and Peter can give you some perspectives from his vantage point down in New York City, and I'll give them from my vantage point here in Albany. But Peter has received numerous awards. Most recently, he was chosen for the Attorney Professionalism Award by the New York State Bar Association, which is awarded to one attorney in the entire state of New York. And Peter was selected for that. So his distinguished career has been legendary. And I've met Peter over 30 years ago through the New York State Bar Association. And I always tell the story about one particular meeting when we got a new law that came in, and we were all of a sudden criminals because they had passed a law that made it a crime for one individual to counsel another on Medicaid, which was a clear violation of free speech. But Peter, at the Bar Association meeting, because everyone was a bit concerned, as you might imagine, who was practicing elder law at the time, we had about 500 people in the room, and we were waiting for Peter to speak. And all of a sudden, out from behind the curtain comes Peter Strauss in a prison outfit, stripes with a ball and chain around his ankle. So he brought some levity to an otherwise very tense situation, and we got our way through that. And the New York State Bar Association actually sued the federal government in that case and got that law overturned. So Peter, welcome this morning.
Thank you, Lou. Happy Thanksgiving to everybody. And I'm not so sure we can bring levity to the subjects that we're going to talk about today, but we're going to try to help you with some hope and some solutions to very serious problems as we all age. And we're hopefully all going to be older at some point.
So for most of you, you're at one stage or another. You're either planning for retirement or you're in retirement. And either case, today's topics will be relevant to you because we all want to maximize our income. And when you're doing your retirement planning during your working years, you're trying to put away into your 401k or IRA or maybe a Roth. You want to maximize the value of your Social Security. You want to look at your pension. How are your investments doing? What is your investment income? So sound financial planning is absolutely essential. We work very closely hand in hand with our clients' financial advisors to make sure that we're covering what I call the offense, and that is accumulating wealth and accumulating income for your retirement. But we also want to work with insurance advisors to talk about risk management, healthcare, long-term care, and other risks that you face during that aging process. And we're going to focus today, obviously, as lawyers on the legal side of this, looking at your wills, trusts, and how you should be thinking about either setting yourself up for the future, or if you need care today, planning in the immediate future to receive that care.
I just want to emphasize what Lou just said, that in thinking ahead and doing our planning, we really need to keep in mind that we may be healthy now, but perhaps the future isn't going to be so good to us. So investing and protecting our assets, as we will talk about today, becomes very critical both for your own economic survival and that of your family in the future.
And if you're a homeowner, think about it this way. You own a home. Do you anticipate in the next year or 10 or 20 or 30 or during your lifetime that your home will burn to the ground? Probably not. Do you have homeowners insurance? Almost certainly. So a good legal plan is insuring against all of the risks that you may face. And some of you may have heard our radio show. We're on every Saturday morning on WGY. We'll be on tomorrow with Aaron Connor, myself, and our associate Teresa Skane. The show is called Life Happens because it does. And when we're looking at life happening every day around us, the COVID crisis has been just a moment in time that I think we will all remember as we have other milestones. We will get through it. Vaccines are on the way, but this has been a very dramatically different time period for all of us. We just had Thanksgiving dinners with very small tables and a few place settings as opposed to the larger gatherings. And so we are living through a time of crisis for many people where life is happening. We have 260,000 deceased Americans who didn't expect to be that way just a year ago. So planning in advance is absolutely critical. We're going to talk about some changes that have happened and that we're anticipating to happen, looking at the core documentation, what we call the core four for your estate plan, trusts and how they play in and why trusts are the best tool in our toolbox to help our clients plan. And finally, an issue that has risen to the top of the heap, fortunately, in President Biden's agenda. So we're going to talk about long-term care and how you can look to finance and pay for long-term care if and when that need arises. This is our firm. These are our attorneys. Peter heads up our New York City office, along with Larice Phillips and Anthony Kachui. And our other attorneys are here in the Albany office. And we are a group that's growing. We have 2 new attorneys starting January 1st and another new attorney here in Albany starting December 15th. So it is a growing group. And let's get into it, Peter. We have a new president, maybe.
Yes, I'm glad you're calling him the president. I don't know whether.
I did say maybe.
Maybe. Well, that's true. But I think it's looking like a pretty sure thing. And the priorities are very exciting for many of us in this field. He's certainly going to focus on the pandemic. He's concerned about what the pandemic has done to our economy, along with other factors. Certainly racial equality and fairness, both in employment and housing, and of course, most perhaps importantly, where there's the greatest discrimination is in healthcare delivery and availability, and of course, climate change and bringing in former Senator and Secretary of State John Kerry to a cabinet level position, which doesn't need Senate approval, by the way, is all very exciting. So these are things we hope we can look forward to. Now, obviously, and you'll see the note here at the bottom of your screen, much of these wishes and goals are very dependent on the outcome of the Georgia 2 senatorial election races on January, I believe it's the 3rd or the 7th, I'm not quite sure. And we all need to be thinking about how that will impact if the Democrats don't capture the Senate of President-elect Biden's program priorities may not be so easily accomplished. There may be some Republican senators who will decide that they are worthy of support, and he may have a majority, even if they don't have an actual majority. And we're going to have to see how this plays out. So it's going to be an exciting time, and what the Mitch McConnell does and what his supporters are going to do may be critical, but I sure hope they're looking forward to the next senatorial elections in 2 years.
And Peter, you mentioned healthcare. We will see how much of an agenda item that needs to be for President Biden, President-elect Biden, based upon the Supreme Court's decision. They heard oral arguments back on November 11th on a lawsuit which would in effect repeal the Affordable Care Act. And there were different opinions on how that argument went and whether the Affordable Care Act will stay with us. And as you know, healthcare was a political issue. with the President Trump saying that he wanted to repeal and replace the Obamacare or the Affordable Care Act. President-elect Biden saying that he wanted to keep the Affordable Care Act and improve upon it. And others further left saying they wanted to go to a Medicare for all or a universal payor program. Which of those is correct and which would be the best for the country is a matter of great debate. The Supreme Court will tell us whether we have the Affordable Care Act any longer or not. If we do not, then that's going to rise right to the top of this agenda. And President Biden, if he is president at that point, will have to deal with healthcare and creating a new healthcare program in America, because we would be basically out of the existing program with no substitute, no replacement bill in place. And Peter, that's a major issue.
Well, it is a major issue. And of course, not only does Obamacare disappear if that happens, but so many of the consequences of that, such as having pre-existing condition requirements pop back up, many other things that we've been hearing about in the campaign. And I think, of course, the Georgia senatorial election results will affect this. I think people are also thinking with great concern that yesterday's, or I guess it was late Wednesday night's Supreme Court decision on the COVID protections and rules in New York State that were struck down on the theory of basically prioritizing religious liberty over all of our other liberties is going to affect this. But I'm not so sure that Chief Justice John Roberts' influence over the new Supreme Court nominee won't hold sway there. I think that we're going to see in matters of religious liberty, the conservatives on the court winning. I'm not so sure in the absence of the constitutional provision about freedom of religion, that some of the other concerns are going to necessarily mean the court's going to strike down new legislation. But let's hope.
Debate the Supreme Court for days and for this entire hour, but I want to move on to long-term care. One of the bright spots is that President-elect Biden has acknowledged the long-term care crisis, has put in place a platform for real solutions to do things, Peter, that we've been trying to do and have been successful at here in New York for many, many years. And that is keep our clients at home, keep them safe at home, and get them the appropriate care to be able to age in place. I have not seen this on a presidential agenda as high up as it is on Biden's, ever. Going all the way back to Lyndon Johnson. They didn't recognize long-term care as a distinctive topic, but over that time since Medicare and Medicaid were enacted, long-term care has been separated out of the healthcare system. We're going to talk very specifically about how that works, but President-elect Biden has put in place a program where he is intending to enact laws that will foster home care, enhance the services available in the home, and bring all of the issues, including mental health, into home health care. Telemedicine is something due to COVID that has just flourished. It's taken off like a rocket, and telemedicine is now in most of our health plans. That's going to continue, and President Trump acknowledged that telemedicine is here to stay, and certainly this agenda does the same. So what they refer to now as long-term services and supports is part of the Biden agenda, and he has some specific proposals also, Peter, for people with disabilities.
Yes, I think that's remarkable. Of course, all of these Biden proposals, which for most of us are very exciting, is going to be very dependent on the budget crisis that both the states and the federal government are facing. So we're going to have to see where the money is going to come from. And the budget issue is one which I believe is why no presidential candidate in the past 50 years has ever really been willing to discuss this subject. But here we are, and you can see here, we're going to have a senior position in the White House dealing with the persons with disability community. That's not necessarily budget related. And the last point here, which is very exciting to me, is that part of his proposals is to review guardianship laws throughout the states We don't have the time today, when maybe that's the subject for another webinar, but guardianship laws need serious reforms. And in many states, we need more protection of individual rights and liberties when someone is trying to take your rights away. And guardianships are unique because they're both beneficent and taking away of your rights. So this is a problem we're going to be dealing with. And it's exciting to see that Biden understands this.
Yeah, we just haven't seen this as a priority in any other presidential agenda. So even if the funds aren't there, at least the policy discussions will be taking place. Every 10 years, they have a presidential council on aging. And that happened under President Obama. And I read the report. There were no answers. There was no prioritization or no recognition even that long-term care and the aging of America is a significant issue, which we now have. And that applies also, again, very, very astutely on his part, to people with disabilities. So
correct. And when we said earlier that the Biden proposals include eliminating discrimination in the delivery of health care, that also includes the delivery of services and needs of persons with disabilities. So even though it may not get the budgetary attention we need, certainly whoever is going to run the Department of Justice is going to be looking at these issues like we have not seen in the last 4.5 years.
Yeah, and just for our listeners to point out that you're not dealing with an opinion that is uninformed. Peter also has taught at New York Law School for many, many years, and he runs the guardianship clinic at New York Law School and teaches elder law there as well. So Peter, that's an issue. This is an issue that you have been dealing with academically as well as in your practice.
Absolutely, Lou. That's correct.
Social Security, the third rail of politics. You don't want to touch Social Security. But the plain fact is that Social Security, as it is currently configured for my children, who I worry about, I think Social Security is pretty secure for me, for my lifetime, but I don't know about my kids. If we keep going with the deficits that we have and the budget and the debt that we have taken on, and just to put it in perspective, we were running a deficit at the end of 2008 when we had the economic crisis of about $1 trillion, $1 trillion. And over the next 8 years, that came down to about $500 billion or 500 billion. This past year, the last 12 months, the budget deficit has been $3 trillion. And due to the pandemic and COVID and the economic issues generated by COVID, we're anticipating more deficit next year. That filters right down to New York State, as we're going to see. So we do believe that steps are going to have to be taken to shore up the Social Security system. And he's looking to tax people who are in higher tax brackets and have them carry the freight to shore up the Social Security, and then provide additional benefits to people who are within the system for more than 20 years to increase their level and to make sure that the bottom rung of Social Security is at least 125% above poverty level.
And I also should point out that the increase for persons been in benefit with Social Security for 20 years will also afford those the older old, with some additional funds to purchase some long-term care, even if they don't qualify for Medicaid, as we will see later on. So that could also impact on the proposal for better home care services.
So the plan to pay for it, $750 billion cost over 10 years, is to put a 12.4% tax on Social Security for anyone above $400,000 in income. And that would be evenly split between employers and employees. And if you remember, our tax rate was up until 2018, 39.6%. That was the highest marginal rate. That was reduced to 37. So for those high income earners, he would increase from 37 to 39.6, going back to the 2017 levels, the top marginal income tax rate. So what does all this mean? The other things that are really meaningful to most clients, because we deal with high net worth clients who will be impacted by those other changes. But for most clients, capital gains are something that you think about. If you buy stock and you sell stock or you sell real estate, there's a capital gains tax rate. And again, President-elect's proposal is to increase the rate, but only for people who have income above $1 million, going from what is a top 20% capital gains rate to a 39.6% or ordinary income tax capital gains rate. The other piece of this is eliminating what's called step up in basis. And we work with our clients on this very hard to make sure that when children inherit assets, those assets go to them with a fully enhanced cost basis, which means when the kids sell properties, homes, stocks, other real estate businesses, they can sell them without capital gains tax because their basis gets adjusted upon death. This provision has been enacted twice. It was enacted back in the 70s and immediately repealed. It was also enacted in 2010. If you remember the Bush tax cuts, which came in over a 10-year span, in 2010, the estate tax was repealed, and they were trying to pay for the cost of the repeal of the estate tax with an elimination of that step up in basis. It is so thorny an issue to administer that 6 months into 2010, Congress had to enact legislation that allowed people to opt back into the step up in basis. So whether this piece will ever pass, my personal opinion, Peter, is no. I don't think they'll ever get carryover.
I agree. These are so controversial, both these points, that I think there will be a split in the liberal community about this, because even though it would raise revenue by taxing the fairly wealthy, it's also going to adversely affect many, many middle-income families, and I don't think it's going to go so very far.
So we are in this country taxed at a number of different levels. Obviously, if you're working, you have payroll taxes, you have a Social Security tax, you have a Medicare tax, then you have federal income tax. In New York and in many states, you have a state income tax, and that's just the income tax side of things. Then you get tax on selling assets. My daughter is studying for the CPA exam. I was tutoring her briefly last night. She's going to be sitting for the CPA exam, and I'm looking at all the different taxes that she has to know, and it's mind-numbing. The level of taxation and the amount of different taxes that we have to face, real property taxes. When we look at this, one tax gets a lot of publicity, but has been put in a place where most people today don't have to worry about it, and that is the estate tax. When we look at federal estate taxes, the Bush tax cuts brought up the exemption from what was $1 million back in 2000, I believe 2000, and then 2001 it started to phase up, and then it went to a repeal of the estate tax in 2010. Then it was extended to a $5 million exemption, and that $5 million exemption was carried through the Obama administration and adjusted up for inflation. Then in 2018, the Trump tax cuts doubled the amount of exemption from 5 million to 10 million adjusted for inflation. So each of you sitting there today, you may be doing some shopping using your credit cards, but you could take out your checkbook and you could write a check today for 11,580,000. Wait till January 1, it'll be $11,700,000, and that is tax-free transfer. Federal gift tax, estate tax, generation skipping transfer tax, the exemption level will be $11.7 million. New York is still at that halfway mark, $5.85 million. One thing that has motivated a lot of clients to take action this year is that the exemption level automatically reverts back, as do all of the personal tax cuts, at the end of 2025. So we're just 4 years away from the reversion of all of these tax laws back to 2017 levels, which would cut the estate tax exemption in half. So people are locking in their exemptions now by making large gifts. And if you're in that position where you have a taxable estate, this is something that you need to consider.
And if the Democrats capture the Senate, that exemption that presently exists could well go down to 5 million again in 2021.
Yeah.
So here at the law firm, we have been counseling clients who have significant means to come over and plan with us to capture those exemptions before the end of this year. And there's not much time left, just because we don't know. We can't wait till January to find out what that answer might be. But in any event, Lou is absolutely right. It goes away in 2025. And if the Democrats are in control, that higher exemption probably would not be extended.
So for clients who are generally at the 5 million or more mark in terms of total wealth, and that includes retirement accounts, life insurance policies, real estate, all of your other assets. If you're at the $5 million mark, then you really need a personal consultation to look at estate tax planning, because once you get above the thresholds, the federal and state combined threshold, you're paying over 50%. It's a cliff, and you fall right off the cliff, and you pay over 50% in estate tax if you breach that threshold. So it's important, it's crucial to get estate tax advice if your estate and your net worth is up in that level. Again, 99% of clients, this is not an issue. So let's go on and talk about something that is an issue, because Peter, more and more, no one has a fixed pension unless you work for the government or you're a teacher. So fixed pensions are a thing of the past. What people have now are 401ks, 403bs, 457 plans, and they roll them out into IRAs, or perhaps you started it as an IRA. Much of the wealth of this nation is held in qualified retirement plans. And the government looked at this and, again, saw it as an opportunity to raise revenue. And part of the Trump tax regime was the Secure Act. So under President Trump, they passed a law that has some benefits. You don't have to start drawing on a qualified retirement plan or IRA until 72, which used to be 70 and a half. So you get another year and a half of deferral of tax. And if you're working beyond age 70, you can now keep contributing to that account. But the poison pill was that when someone dies and another person inherits the IRA, unlike old law where you could stretch it and take it out over the lifetime of the beneficiary, the IRA now has to come out over a 10-year time period. So if you think in terms of most of our clients' wealth, in many cases now, is in retirement accounts. And now it goes to the kids, but they have to take it out over 10 years and pay all of the income tax on that account over that 10-year time period. So this is a major change. It's changed the way we plan for retirement benefits for next generations. And there are some important exceptions, Peter, that give you a safe harbor.
Correct. Your spouse can still receive your benefits over the spouse's lifetime. Minors, children only, not grandchildren. And the third point here is very critical for many of our clients, third and fourth. A child with a disability or someone who is chronically ill can continue to receive those benefits over a lifetime rather than limited to the 10-year rule. And we do a lot of planning around this. So depending on the structure of your assets as a whole, maybe we want to shift those alternate beneficiaries on the retirement plans to take advantage of these exceptions, perhaps by setting up a trust for a child with disabilities and front loading that with retirement funds and make up the difference with other children with assets that are not retirement funds. So there's a lot of planning. And again, you need to talk to your financial advisor about that.
So one of the things that people are doing is to convert a traditional IRA to a Roth IRA. And the Roth IRA, if you can get it funded or if you convert to it, is a gift, because it allows you to defer taxation and pay no income tax on any of the investments held inside the Roth. And then when you take it out, you pay no tax on any of that appreciated value, which is a phenomenal benefit. And we are seeing more and more people exercising their right to take traditional IRAs and convert them over to Roth IRAs. When the beneficiary then inherits it, they do have still a 10-year rule to take it out, but it comes out fully tax-free. And the beneficiary, like you have no required minimum distribution on a Roth, so you can let it accumulate tax-free right up until year 10 under the Secure Act, and then take it all out, and it all comes out as cash tax-free. So Roth conversions are very popular. We did a webinar back in March or maybe February when this Secure Act passed, and that's on our website, as are all of our webinars. So you're welcome to view this for free. It's a 60-minute webinar on just the Secure Act, and you can always find those at pierrolaw.com. Go to the events tab and you'll see all of our prior webinars, including webinars on the Medicaid changes. And Peter, this is the shift in New York. This kind of runs counter to what President Biden is proposing, because New York has had the most beneficial home care program under Medicaid in the country for many, many years. Now New York, because of its own budget deficit, has had to retrench on that and impose new restrictions on home care Medicaid.
Yes, and we have been very fortunate over the years to be able to do planning to make someone who has significant deficits eligible for the Medicaid program, which we'll talk a little bit more later if we have time. And everybody understood that if you needed Medicaid for nursing home care, there would be a period of ineligibility if you made gifts of your assets within a 5-year period prior to the need for the nursing home. And we did not have this penalty potential with Medicaid, community Medicaid, and New York having a generous Medicaid for home care. We were able to keep a lot of people by making them eligible, using asset transfers, which we hope to talk about a little bit later. And there were no penalties, no waiting period. That has changed, so that we now have a 2.5-year look back period and the potential for significant waiting periods because of ineligibility based on gifting. And again, we're doing a lot of counseling about how to deal with that, meaning that we really have to act very quickly within the next few months and prevent the application of those rules.
Due to COVID, the implementation of the rules has been pushed back twice. It was originally scheduled to go in effect on October 1st. It was then pushed back to January 1, and now it's pushed back again to April 1. So the rules will not be fully implemented until April 1, but it's important to know that this changes the whole landscape, not just of the financial eligibility, but your ability to use your own physician to support a Medicaid home care application, your ability to get your own assessment done. They're going to have a uniform assessment tool and a new assessment vehicle or company that's going to be doing all of the assessments in New York State. They haven't unveiled who that is yet. Major changes, though, are coming April 1 to the home care program. So if you're on the cusp, if you know someone who may be able to benefit from home health care services, the time to apply for Medicaid is now. Get in under the old rules, get grandfathered in, and this is your best chance to age in place, as we're going to talk about in a moment. But the transfer rules go into effect April 1, but they revert back to October 1st. So if you give away assets, if you're making transfers, creating a trust, gifting to kids or grandkids, however you're doing it, come April 1, when you file your Medicaid application, they're going to look at all transfers on or after October 1st. They aggregate the value of those transfers and then assess a waiting period, or a penalty as we call it, based upon a formula. About $11,000 divides into what you gave away, and you come up with a number of months of ineligibility. Again, if you apply before April 1st, none of that applies to you. After April 1st, you have to know how that look back and penalty rule will work. This is going to apply to a whole host of different home care programs under the New York State Medicaid program, and there are many. You'll see them up there on the screen. One major exception is the Nursing Home Transition Diversion Waiver Program. So far, they've exempted that out, which is an important exception. And we have a whole unit, a whole department in our law firm that does Medicaid applications day in, day out. They know these rules extremely well. If you want to get a consultation and learn what your rights are to the Medicaid program, they would be happy to meet with you and walk through all of these rules and potential changes and assess your own personal situation. So Peter, we've always had the 5-year rule, well, not always, since 2006, we've had the 5-year rule, and most people are familiar with that. But this now brings in a 2.5-year look back for home care benefits. And people really need to take this planning seriously if they intend to get the coverage under the Medicaid program.
Absolutely. And even if your parents are resisting this, which is a major problem, to convince them that they really do need someone to come in and help them out with some services, even if you start with just a few hours and get in and get grandfathered, then you would be avoiding these new draconian rules. And so it might be a good idea to have another heart-to-heart talk with Pop and try to get him to cooperate in doing this. It's legal, it's right, it's ethical, and we have to do a better job of convincing our older clients that this is something that is really significant for them.
As we mentioned earlier, the Medicare program does not cover long-term care, and that surprises many seniors. Most seniors have just been deluged with Medicare supplement policies and Medicare Advantage plans because it's open enrollment season for those supplemental insurance plans. But what those plans do not cover is long-term care, meaning if you want home health aides, you want to be in home and get care in your home, or you need assisted living, or you ultimately need a nursing home, none of that is covered under Medicare. Medicaid does cover it, but these are the eligibility limits. $15,750 in total assets, $895 in income for an individual to get Medicaid home care. If you're in a nursing home, the same asset limit, but $50 a month is what you get to keep of your income. Planning for Medicaid is crucial because these are very difficult levels to hit for both income and assets, but there are still many planning avenues, we're going to get to a couple of them later in the program, available to be able to hit those targets. So if you want to do a poll with us, we'd love to have you participate. We just want to get an idea on what you have done. We're going to pivot now to the planning side of the program. What have you done to plan so far? Just met with clients on Wednesday who came in and they're in their late 60s and they had nothing. Smart people, both working really hard. They both just retired, but they needed a full array of legal documents. What have you done so far? Have you done a will? Have you done powers of attorney, healthcare proxies? Have you done a trust? Or are you one of those people that's just getting started? I'll give you about 20 seconds to give us your answers. Well, maybe 10 seconds. Hopefully you've all been able to pick up your mouse and click on the appropriate boxes by now. 3, 2, 1, pencils down. Let's see our results. So 79% of you have a will. That's pretty good. You're an educated audience because the national average is about 60%. 71% have advanced directives. About half of you have done trusts, and 17% of you are just getting started. So that is actually an excellent result.
It is, because the state statistics show that as far as advanced directives, only about 30% of New Yorkers have advanced directives. So Lou, we're talking to a highly sophisticated group of people today.
They're educated, Peter, because we believe in education, and hopefully after today, they'll be a little bit more educated, as will we. But when we talk about estate planning, we try to identify the goals, and that's our objective. Our goal is to get your goals, and our job one is to make sure that the plan that we create for you and construct is going to meet the goals that you identify up front. So goal evaluation, identification is absolutely the first step. Then we get to who do you want to make decisions for you if and when you can't make them for yourself, a very critical aspect of estate planning. We're going to talk about a number of documents where that plays in. Do you want to be able to protect assets and income for yourselves and ultimately leave that legacy on for your children so you can give them the ultimate gift of an inheritance that they can then utilize for their own families and your grandchildren ultimately, and addressing your desire to provide that legacy while keeping yourself out of court. And our clients end up in court, Peter, in two main situations. And one of them is during life, and one of them is after death. So let's address the lifetime issues that people face.
Well, I think that's perhaps the most important goal, because if you do wind up in court, you may have people chosen to be your managers, your fiduciaries for your power of attorney, your advanced directives, your healthcare proxy, and that may be something you might want to avoid. But one of the obstacles for many of you in thinking about planning for yourselves or your spouse, partner, or your parent is that you have been told that your parent or this loved one has some kind of dementia, and they're not able legally to do advanced planning. And I want to assure you that that is not really true. Traditionally, physicians and psychologists have said that capacity to do these things is like an on-off switch. You either have it capacity or you don't. And that's really not true. Modern theory of medicine and psychology is that capacity is very task specific. You may be able to sign a healthcare proxy, but not a more sophisticated power of attorney that has a gift provision in it. And this is a little test that I've devised. First of all, in many cases, particularly if you expect conflict within the family, you might want to have a capacity test performed by a physician or a psychologist. But even if you don't do that, if you think it's too late, just look at these guidelines that we've developed here in the firm. And if the person is able to sort of pass this rule of thumb test, that they know that they have difficulty in making decisions about their healthcare or financial management. If the person they want to choose to be their healthcare proxy agent or agent on a power of attorney is reasonable, if it's consistent with your lifetime decisions and actions during your life. And thirdly, if you can articulate why you need a particular document, I think that you could go to an attorney, have that decision thinking reviewed, and move forward. Don't assume that it's too late. I think that's the most important message I can relate to you about this particular issue.
And that relates back to the guardianship law in New York, which changed a number of years ago. There used to be a very strict medical standard of competence versus incompetence. But the New York legislature rejected that concept and put in this functional capacity test for guardianship. And really, Peter, what you're doing here is kind of relating back to that standard in the ability to sign the advanced directives that put that person in place to make decisions on your behalf versus having a court have to do it.
Correct. And the law has a presumption that you have capacity unless physicians have determined that you don't, or a court has determined that you are a, quote, incapacitated person. So there's a lot of flexibility here. And we urge you all to really address these advanced directives. That's the healthcare proxy and living will, which I prefer to call a healthcare declaration, because it's an expression of your wishes about the kind of care and treatment you would want or perhaps forego towards the end of your life.
So our firm does a lot of litigation, and in our planning side, we do a lot of work to keep your family out of court. So the core documents, the things that everyone should have in their core estate plan, include the power of attorney and the healthcare proxy. You should also have documents that upon your death kick in and allow you to do the planning post-mortem, if you will, through your agent. So you appoint an agent to control your burial and funeral arrangements. You appoint an executor under your will to control the disposition of your property. And those 4 documents are relatively straightforward, some very significant nuances, but everyone should have those. And people ask what age is appropriate. Many people bring their children in at 18 to do some of these documents, at least the power of attorney and the healthcare proxy. I know when my kids went off to college, I wanted to have the ability to deal with their school if they went to the health center to get information. So it really is never too early other than before 18. But once you're 18, these documents, this core is an important core to have in place because you just never know. And Peter, you, I know, have a particular passion for the healthcare proxy. And it's something that our firm has worked extensively on, creating potent language to enforce wishes.
Absolutely. It's a critical document and everybody should have one. Don't assume, for example, that your 23-year-old child who's on the autism spectrum is incapable of executing from a legal perspective a healthcare proxy. If you go back to these little tests that I've developed, I think you can see that it may be very possible and critical. The last bullet on that slide that just flashed by us deals with a very important point here. Many physicians will not honor the wishes expressed in your living will as advocated for by your healthcare agent. And we want you to know that we feel this is a very serious issue. Compliance is very spotty, and we've developed some language in our living will section of our healthcare proxy that really deals with this, and we think will go a long way to making sure that your wishes and your independence can be maintained later in your lifetime.
So Peter, we have about 10 minutes left, and I want to talk about trust planning. We're going to talk briefly about revocable trusts and then about long-term care in the next 10 minutes. And trust planning is a plan that really gives you the best chance of success. A revocable trust is very simple. You are the grantor, you are the beneficiary, and you are the trustee. So you're wearing all three hats in the revocable trust, and it keeps your family out of probate court, and it is the most secure way to have your assets managed if you do have some event that renders you incapacitated. It creates efficiencies, time saving, money saving, and a lot of angst and anguish. And certainly if your plan may be contested, having a trust is a best defense to a potential contest. Revocable trusts organize your assets. You are the initial trustee, so you manage it, run it. If you can't, based upon a physician's opinion that you're no longer able, typically that's the standard, then you have successors who you appoint to make the decisions for you, manage your assets, and make sure they're used properly. Upon your death, no probate. Every will must go to court. There is no will that works magically on its own. It is only a document that has effect if a judge orders so and issues something called letters testamentary. A trust doesn't need that court process. So you have an efficient, seamless, virtually simultaneous transfer of authority to a successor trustee you have appointed to manage your estate for your spouse, your children, your grandchildren, and to do the planning that you want. Because it's a revocable trust and you're in full control, we put everything possible into that trust. You fund it entirely, and it's critical that you do so. Make sure that all of your assets are either titled in the trust or the trust becomes the beneficiary of those assets, because if you leave assets hanging out there, you may well end up still in probate, and that's not the desired result. So
I can't emphasize enough how much this point is critical. Having the documents executed and in your file or in the file in your lawyer's office doesn't help if you haven't changed the beneficiary provisions where those assets may go to people that shouldn't be handling them. It's very critical to integrate all of these assets into your trust.
And we have a trust funding kit here at the law firm that we provide to our clients on the day they sign their trusts. And we've actually created a position within the firm called our trust funding coordinator. It is so important that we have someone dedicated to assisting our clients in that trust funding capacity. Next generation, this gets into the legacy planning. I know for myself, I have 3 children, trust them. They're children who I think can do a good job managing and maintaining their own estates at some point in time. but I don't know who their spouses will be. I don't know what their health will be long-term, and I certainly don't know whether they may have some liabilities down the road. So I looked for, and we came up with a number of years ago, a type of trust that satisfies the goal of protecting assets for our children while leaving them in complete control. We call it a beneficiary controlled trust. And so that is the legacy that you can leave to your kids. They get full access, full control, yet no risk. Divorce being the number one issue for most parents. When we talk about this type of trust, what if your family inheritance goes to your children and they later get divorced? Is some of that or half of that going to be lost? Not if they do it properly. And Peter, not all trusts are created equal because not all beneficiaries are created equal. So there are varieties of trusts for children that may be enacted.
Correct. As our audience will note, that the third child here in this chart is a child with disabilities. So in that case, we don't want to create the classic beneficiary control trust, because if the person with disabilities may need Medicaid, that control and the ability to manage will make them ineligible. So now for that child, we want a supplemental needs trust, which we hope to have a little time to talk about later. But you can see how flexible this is and how important it is to think this process through on a multi-generation basis.
And Peter, I'm going to skip ahead a bit because we are running short on time, and I'm going to go right to the long-term care area, because again, for most clients, that $5,850,000 New York State estate tax threshold is not a concern. If it is, then you address it. But if it is, then you're probably not as concerned about long-term care because you have sufficient income and assets to pay. But long-term care, nursing homes is what most people think about. But in our firm, it's home health care. That's our primary thought. Assisted living is in between. Only 3 ways to pay for it. You can pay for it out of your pocket. Average cost of nursing home care here in Albany is about $15,000 a month. Downstate, it's even more expensive here. And you can buy private insurance to offset the cost of long-term care, or you can rely on the Medicaid program. It doesn't get any more complicated than this. So ask yourself these questions. If I ever do need care, and we have clients in their 20s who need long-term care, clients in their 90s and 100s who need long-term care. It isn't age restricted. It's about your condition. Did you have an accident, an illness that befell you and rendered you in need of services, those long-term services and supports in the home? Who's going to provide that? I don't have any hopes that my kids are going to move in and start taking care of me and giving me showers. That's not going to happen for me. But I want to have in place a plan that allows me to have coverage and enough money to pay for services. So Peter, insuring the risk is one way to go about this.
Absolutely. That's, I think, the first thing that we talk to clients about, looking at their wealth, their cash flow needs, getting their financial planners to put another 2 pages in that 1-inch thick plan to show the effect of long-term care on their ability to function and the wealth that they have. So we're very strong on long-term care insurance with all of its problems today. And we ask clients to look at that and consider some of the new products that are called hybrid products, where there's combination of life insurance and funds that would be available for long-term care. Those are the hybrids. And then, also reverse mortgages, although they could be expensive and there are strict eligibility requirements. Reverse mortgages on your home could be a very good source of finding cash to pay for long-term care if, for a variety of reasons, you might not be eligible for Medicaid or you're not able to do that. Keep in mind, for the downstaters, you can't get reverse mortgages on co-op apartments right now. And then you may not have thought of this, but life care communities, congregate care facilities, where you buy in and your maintenance as you move up, your monthly costs as you move up from independent living to assisted living to nursing home may not change. That's all part of the package. That's a kind of insurance in effect. And if you can leave the sidewalks of New York has several of these. Pennsylvania has some wonderful ones, as do Connecticut and Massachusetts. And then, of course, we come to Medicaid, which in one sense, we talk to clients about being the payer of last resort. It may be the only payer available to a lot of people, but we want to put it in that perspective. It's always not the first thing we talk about. So how do we get?
Because of the escalating cost of long-term care, Medicaid has become essential, even in cases where you own long-term care insurance, because the benefit may not be sufficient to cover the entire risk. So Medicaid puts the backstop and becomes that payer of last resort, whether you're paying the first dollars out of pocket or whether you have first dollar long-term care coverage. Medicaid is based upon a means test, which we talked about earlier, 15,750 of assets, 895 for home care and income. One of the main tools to plan for this, and this is our last topic for this morning, so you can take a breath, we're almost done. Medicaid Asset Protection Trusts, something that has been with us in the law since really the inception of Medicaid, but 1993, this law was carved out, and the trust rules we have today have been with us literally since 1993. So for people who need that added level of protection of having the Medicaid backstop in their plan, creating a trust with as much flexibility and control and having the ability to have that trust be sheltering of assets is critical. So when we look at our Medicaid Asset Protection Trust, we put assets in such as your home and other assets we'll get on the next slide. You can keep the income from all of those assets, the right to live in the home, you keep your star exemption. So the trust looks and feels a lot like what you have today, and really looks almost similar to the revocable trust, except two things. Number one, we don't recommend that you serve as your own trustee. So you need to have a third-party trustee. In most cases, that becomes the children or family members who are going to step in and serve in this capacity. Again, each situation is unique. There are different permutations on the plan, but that's the most likely scenario. The trustee manages those assets. You keep the income, the right to live in the properties, and your beneficiaries, your children and grandchildren, can receive that principal. They will inherit the trust when it ends. And again, your home, bank accounts, stocks, bonds, annuities, life insurance, businesses, real estate go into the trust. You keep the income. Principal during life can be paid out to the kids. So I trust my children. If I need to get something out of my trust, I want to go buy that new car, my kids can take the money out of the trust and write a check to the dealership. The money is always available to improve the home, to do maintenance on the home and repairs. So this trust, as designed today, is extremely flexible, and you retain significant controls, because if you do appoint one of your children and they go off the reservation, you can change it. You can fire them and hire one of the other kids and put them in as your trustee. You can always change beneficiaries, which is a more potent stick that you have over the trust, because if someone knows if they're not acting in accordance with your wishes, you can remove them as a beneficiary. That becomes a very important point, as you might imagine. And because New York law has a provision in the Estates, Powers, and Trusts law that says, with the consent of beneficiaries, a grantor can change and revoke even an irrevocable trust. You retain ultimate control. So now we really look like a revocable trust if we have control over the beneficiaries. And oh, guess what? You do. Remember that you can always change beneficiaries. And if you can change beneficiaries, that means that you can put people in who will consent to the revocation of your trust. This is the way the trust works today. The assets that stay out, you keep enough cash in your name, you keep your bank accounts, IRAs, and 401ks. The good news in New York and in Florida, but not in most other states, is that IRAs and 401ks are exempt for Medicaid purposes. You only have to take your minimum distributions out. So that becomes a very important point, because we keep control, we keep access to the IRA money. The other assets go in the trust. We have the power to change trustees, beneficiaries, and even revoke the trust at the time that we want to get assets back. And this is what an overall plan may look like. You see the IRAs in a separate box because they're already exempt. We collect our required minimum distributions. For a married couple, we usually keep about $75,000 in liquid assets in their name, because under Medicaid, one spouse, if the other needs Medicaid, can keep that amount. We have the home, rental property, stock, CDs, annuities in the Medicaid Asset Protection Trust. If we need to unlock that piggy bank, we need to break the bank, our kids can get the money out, or we can use that provision of New York law to actually break the trust. We keep all of our income coming in. So you see, you keep and don't lose any income in this asset protection plan. You keep access to your required minimum distributions and your IRA asset. You keep a certain amount of cash in your name for your own personal use. And if you ever need to tap the bank on the right, the Medicaid Asset Protection Trust, you can tap it through the kids. When mom and dad are gone, the children have their beneficiary control trust or special needs trust, or whatever type of trust is available and is appropriate for that beneficiary. When I put limited time only, Peter wasn't sure what I meant there. New York last year had a $6.2 billion deficit. This year it's projected to be $15 billion. Most of that is Medicaid. So we are anticipating that Medicaid will be making further changes to eligibility rules. Our trust has been a sacred cow for a very long time, but you know what? Just like home care, we thought would never have a penalty period, these trusts could well be changed, and the rules pertaining to trusts could well be changed in the future. So if you are contemplating this type of planning, the time to get in is now, before any changes occur, because budget deficits and debt, as we mentioned earlier in the program, are going to be affecting every aspect of our financial lives. So planning early, Peter, is absolutely key.
Oh, yes. And one final thought for me, and I think this is important. Don't be discouraged by what you are told by a social worker at a nursing home or an assisted living facility. Don't be discouraged by what you may read on the internet, because you may be hearing or looking at rules that don't apply in New York, but other states that are more restrictive. Get independent advice and get it early. And you'll see on this slide the importance of planning early for a variety of reasons. And we can't emphasize enough that if you see problems down the line, get advice now and act now before it's too late, the rules change, or your situation changes.
Yeah, I couldn't agree with you more, Peter. So many clients come in and say, well, I went to the county Department of Social Services, and I say, stop right there. And I tell them all the things that they were told by the social service worker, like, you have to spend down your IRA, you have to spend all your money, you have to come back when you have that $15,750, nothing you can do about it. People are told that every day.
Right.
It's not true.
And those are the same people that don't call the Internal Revenue Service for income tax advice.
I'm here from the government, and I'm here to help you.
Right.
The other people that are well-meaning are your neighbors, the people you meet in the checkout aisle at the grocery store, your uncle who may have done this 25 years ago. Things change, and you need someone independent who has knowledge and experience and is dealing with these things every day. The other area that we offer at our firm, which is an addition over the last few years, is we actually have social workers on staff now who are geriatric care managers who help our clients through these difficult situations. And that is a service you can access through the law firm as well. So we're running a little bit long. If you want to get up, take a little break, get a cup of coffee. We have some questions from our viewers. We're going to go through those questions. If you don't have the time to stay with us, you want to go get in that line at the mall, then we want to thank you for joining us today. And if you do have further questions, we're going to give you our email addresses right here. And you can email Peter or myself, and we'd be happy to respond to your own individual questions. And you can always call us here at Pierro, Connor, and Strauss, and we'd be happy to sit down with you one-on-one. A question that a lot of people have is, how do I get started? What do I do in order to gather up all of the essential information and take an inventory of what I need to do to plan? And we have questionnaires that are available to you. They're on our website, or if you want to email us, we'd be happy to send you the questionnaire. And that questionnaire will give you a roadmap to follow to start the process of putting your plan together. We love to sit down with our clients with that questionnaire and go through their own particular situation. We can then make very detailed recommendations for you as to how your plan will work and what things you may want to consider. I want to thank you for joining us on Black Friday. Hopefully this has been an informative session. As always, email us or call our office. We're here for you. Peter, I'm going to give you the last word.
It's been a pleasure, and while we've covered a lot of ground today, I think these are really important subjects. We're happy to help, and we're happy to see you either at our upstate office or in our New York City office, which is growing. And I think that we will always tell you the truth. I think that we will find the answer if we don't know it, and we hope to look forward to working with you.